Thank you, Mr. Chairman. I agree that it's very important for everyone to have zealous advocates defending them, even when, especially when, you've got an unpopular client who's been accused of a heinous offense. Everyone needs zealous representation. I think there is a line that has to be drawn, though, between zealous representation and arguing things that are indefensible. Now, when Senator Hawley read the quote from you a few moments ago, the quote from Chief Justice Castile from the Pennsylvania Supreme Court, these are pretty legitimate concerns. It's a rare thing in my experience. And I've worked in civil litigation, I've been a prosecutor, and I've also been involved in criminal defense. It's a very rare thing for a judge to use words like describing a particular office as engaging in repeated attempts to unsettle and undermine the law. What I was perhaps even more troubled by was your response. If I understood you correctly, you said that was just his opinion. There is a difference between an individual expressing an opinion and a judge before whom you're appearing making these arguments. These are arguments that a judge makes when imposing sanctions. And ordinarily when I see a judge express things like this, it's a very rare moment, but it's almost always accompanying a finding that it's time to impose sanctions. So do you want to explain what you meant by when you said that was just his opinion?
Senator, I agree that the quote that Senator Hawley read was from that concurring opinion. I can't tell you what the foundation of that was. It was about my office, that Justice's opinion of my office writ large. I'm not.
But he wasn't making it in the abstract, was he? Not just in the abstract. He was making it in a particular context.
I understand from Senator Hawley that he was making it in the context of a concurring opinion in that appeal.
In that case in which you were involved as a lawyer.
That's correct, Senator Lee. I do not recall being involved in that particular appeal, however.
Now, Judge Castile cited two other cases where these tactics were apparently used by your office, and I'd like to know whether you were involved in either of those. Were you involved in Commonwealth versus Porter or Commonwealth versus Abdul Salam?
I was not.
And even if you weren't involved in either of those cases, you have made statements that appear to appeal to some of the same tactics. In a presentation you gave entitled, quote, Appeal to the Equities, this instruction was given, quote, argue anything and everything you can think of to get your client tolling, because if his claims are untimely, they'll be dead before they even begin. Do you want to clarify what you meant by that statement?
Senator, I don't recall that presentation or that statement.
Okay. Happy to follow up on this in writing and supply you with additional background if you'd like. Now, I want to follow up on another line of questions you got from Senator Kennedy. Senator Kennedy was asking you how you felt about someone having a policy of just not prosecuting certain crimes, certain entire categories of criminal offenses in pursuit of a social justice objective. You didn't answer that. I'm still trying to understand why. I understand that prosecutorial discretion is a thing. It's an important thing. It's a thing that represents the fact that in any prosecutor's office, there are finite resources. You can't go after everything all the time, so you have to go after the cases that you can handle and handle that effectively. But that very same purpose is not only not served, it's actively undermined if a prosecutor says, I will not be prosecuting offenses A through G. I just won't be prosecuting them. Your refusal to answer that question and provide an answer like that is troubling to me. Do you want to explain why you're not willing to answer that one?
Senator, I recognize that the decisions that prosecutors make are complex policy decisions. I do not have all of the information relevant to those decisions, and I would rely on prosecutors to make appropriate decisions about the use of their prosecutorial discretion, and any legal challenges to that I would certainly review. But again, I do not feel informed enough to have a view on that question.
Yeah, but typically, and in fact, I could modify that by saying universally, legal challenges to a prosecutor's refusal to bring a case aren't really a thing. It's not how the system works. It's not. You don't bring the case about the dog that didn't bark, and you also don't bring the case against the prosecutor who didn't bring a case. It doesn't mean that there aren't important questions of discretion, and it isn't prosecutorial discretion when you notify people in advance before they've even committed the crime that those crimes won't be prosecuted. And so of all the questions you've been asked today, this one strikes me as one that should have been the easiest to answer, and that's why I'm so perplexed by it. I'm not sure that I've encountered another nominee before this committee who has been unwilling to answer a question like that. It seems like the easiest question of all to say, yeah, a prosecutor should not categorically announce that he or she will never prosecute an offense in this category on the basis of a social justice concern. Can you help me understand that?
Yes, Senator. And in my career as an advocate, I have focused on specific challenges in specific cases. And if confirmed, I would focus on specific challenges in specific cases. And I am required as a judicial nominee to refrain from comment on matters of public policy, such as the one that you've raised. I understand those are issues of grave importance, and I defer to policymakers to make those decisions.
Hiding behind the cannons isn't appropriate here. Isn't requiring you to comment on a particular case. I have grave concerns with your refusal to answer that. Thank you.
Thank you, Senator Lee. And Senator Ossoff is next.
Thank you, Mr. Chairman, and congratulations to you both